Hello everyone, my name is Indrani Mukherjee. I am a third year law student of Xavier Law School, and today's topic of discussion is about writs with special reference to habeas corpus. Now, as long as I remember, administrative law in its persistence, it did not take so much of highlight in India, majorly because the parliamentary actions that were there at that point of time, it did not let it grow the growth that we in comparison to the growth that we see today. Now, with this administrative actions that have come into place, say in a lot of day-to-day actions that we see, suppose for example we see the traffic rules, sometimes it so happens that arbitrarily they will stop us, and at that point of time a layman doesn't know what to do, so there is arbitrariness coming into that executive action. Now this is what is kind of incorporated into writs as well. Now the concept of writs has particularly come from England, where there back then used to be a thing of discussion, because back then it was not a questionable nobody could question the fact that the queen or the executives in action were to be kind of questioning their actions, so nobody used to raise their voice against that. But in due course, as and when the technological seriousness has come, the societal seriousness has come, as and when the education has started developing, we have seen that the constitutional rights and the awareness to these constitutional rights and the enforcement of these constitutional rights have come into being through these writs. Now we are talking about writs, but why writs in particular way through the administrative law? Now we have seen that administrative discretion is something which consistently every now and then we are experiencing. For example, suppose SEBI is a quasi judicial power which has been delegated to the SEBI board in form of, say, the SAT, the SEBI Appellate Tribunal, and all of the decisions which are given by SAT, they are bound to follow the principles of natural justice. We have learned and read that principles of natural justice is something which is divine in nature and something which requires to be followed at a very initial stage. And these quasi-judicial bodies, which are the administrative bodies, to make the work more delegated in nature by the parliament through the mode of statutes, have been given the power to hear matters, and the burden of the courts can be reduced through these ways. Now why these writs in administrative law is particular to be known to us with special reference to habeas corpus is because if we will refer to Article 32 of the Indian Constitution, we will find that through Article 32 of the Indian Constitution, which is regarded to be the heart and soul of the Indian Constitution. Why? Because through this procedural way, all other fundamental rights can be enforced. Dr. Bhimrao Ambedkar had quoted this to be the heart and soul of the Indian Constitution, and this is particularly very, very paramount to be learned through administrative actions. Or for all those who will be watching this video, I request to kindly refer to Article 32 of the Indian Constitution under right to constitutional remedies. It says that under Article 32, Clause 1, the right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed. 32 Clause 2, the Supreme Court shall have power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari. Now while we are referring to Article 32 Clause 2, it is written, the Supreme Court shall have the power to issue directions or orders or writs. Now, segregating all these parts, we will find that first and foremost thing of highlight is that the Supreme Court shall, that means it is mandatory and binding on all other bodies, all other quasi judicial bodies, all administrative bodies to follow whatever Supreme Court as a direction will be giving. Now, the Supreme Court shall have power to issue directions or orders or writs. Now, writs in particular is not defined anywhere, but writs in context to the Indian way is that these are the modes by which our fundamental rights, if at all violated by the state. Now, state is to be the state. The definition of state has to be according to Article 12 of the Indian Constitution, which states whichever institutions that are run by the government by the very virtue of what government has in it and has to disseminate it to the people is defined under Article 12 of the Indian Constitution. Now, while it says issue directions or orders, these are mandatory issue of directions or orders or writs. Now, writs, again, as I have mentioned earlier, there is no proper definition to writs, but writs can have not a proper definition, but writs can be said to be those instruments by virtue of which the courts, the High Court under Article 226 of the Indian Constitution, or the Supreme Court under Article 32 of the Indian Constitution, confers the rights given to each and every individual to state and bring up their grievances, bring up their violation of rights that has been done by the state, and give it a notice to the Supreme Court that it is time for the state to enforce their rights. Now, the Supreme Court and the High Court will issue directions, issue order to an individual or an enforcement authority who have violated the fundamental right. Now, if on a careful perusal of this chapter, you will see that Article 32, which is also a fundamental right, is under Part 3 of the Indian Constitution, and Part 3 of the Indian Constitution deals in elaborate about the fundamental rights of a person. Now, when any individual who is while disseminating their authority, disseminating their power, there are some or the other problems that will occur, and these problems can be curated, they can be cured, they can be put back into place by giving the rights that the individual is asking, only when the rights of the individual who is asking his own right or her own right is valid. So these enforcements are done through writs, and we will be discussing it by way of Article 32 of the Indian Constitution and Article 226 of the Indian Constitution. Now, as I was previously mentioning about Article 32 of the Indian Constitution, we have seen that under Article 32 clause 1, again I am mentioning and reiterating that an individual has a right to go to the Supreme Court, and Supreme Court under Article 32 is bound to hear the petition, hear the writ petitions. Again, in Article 32 clause 2, the Supreme Court have the power to issue directions or orders or writs. Now, with special reference to habeas corpus, which my topic is, which will speak volumes about habeas corpus. Now, any enforcement authorities are bound to follow what the Supreme Court has given as directions, as issue of orders to those enforcement authorities. Now, under article with now going to article 226 of the Indian Constitution, which whereby the high courts have also the equal rights to enforce these writs by way of enforcement of these writs from the administrative discretion violation that has taken place, which is said to be a necessary evil. Now, these discretionary powers from time to time and from place to place differ. So, for example, any detention that is happening by the police, any police force is detaining a person for more than 24 hours and not producing him to the nearest magistrate is a violation of the very principle of natural justice, because the principle of natural justice inhibits the quality of audi alteram partem, which is fair hearing, which is rule against bias. Now these rule against bias is what the habeas corpus will also talk about, and I will take this up in later section of the video. Article 32 and 226 of the Indian Constitution is invoked within the purview of the Constitution for those administrative actions within the definition of administrative law, with all those administrative actions that take place within this arena where the maintainability of Article 32 is questioned and it is invoked is by way of three methods, or by three ways by which the articles as mentioned 32 and 226 can be invoked. First is when any quasi-judicial action is ultra virus in a way that it infringes the fundamental right of the individual. Two, that any quasi-judicial authority is acting without jurisdiction or assumes wrongly the jurisdiction. Third is that when the procedure obtained by the quasi-judicial actions or the quasi-judicial authorities are itself beyond the Constitution, which is ultra virus to the Constitution. Now, it was in the earliest case of Calcutta gas case in the year of 1962 that in this case the habeas corpus is not only the man who is or detained in confinement, but any person, provided he is not an absolute stranger, can institute proceeding to obtain a writ of habeas corpus for the purpose of liberation. So, by this way, we have learned that the matter in front of the Supreme Court, either in front of the Supreme Court or in front of the High Court, is not how much of the obviously the legality portion is involved in this writ, but it is also very, very important to understand that from all the cases, from each case to case basis, there are facts and circumstances that lead to certain discretion where either the writ is accepted or writ is refused. Mainly writs are accepted because of the fact that a fundamental right, the gravity attached to the fundamental rights and invocation of Article 32 or 226 is of such nature that the fundamental rights against the state is being asked by an individual. So it definitely has some very pertinent questions answering the fundamental rights of an individual, which is which cumulates the fact that all not only the habeas corpus which is in the discussion today, but all writs are so important, which works cumulatively to decide the future of justice by way of precedents, the judicial precedents that are set by the judiciary through this control, the judicial control of administrative actions by way of writ jurisdiction, which definitely is one of the biggest power given to the Supreme Court to thrive the very nature of justice. So the next part of this video contains the informations that we require about habeas corpus as a writ. Now, writ jurisdiction under Article 226 of for the High Courts to issue writs, and under Article 32 of the Indian Constitution by the Supreme Court exercising the writ jurisdiction is defined has defined 5 writs, and particularly in this video I will be dealing about habeas corpus. Now, habeas corpus, one of the types of writs issued by the High Court under Article 226 and by the Supreme Court under Article 32 of the Indian Constitution, states literally to bring the body. Now, a lot of times while exercising, more often than seldom, we have seen that under the criminal laws, whenever a person whenever an individual is brought under custody, the rule under section 56 of Code of Criminal Procedure states that any individual who is brought under custody has to be produced to the nearest magistrate within 24 hours. Now, within those 24 hours, what would be the treatment of the individuals? Nobody knows. That is administration. Now, without any reason, without any reasonability, any individual who is brought under custody is not fair, it is not reasonable, and this is where the writs come into play. Now, the procedure of following up with the habeas corpus writ is that any person who knows the detainee and who has any type of connections or any type of knowledge that the detainee has been detained wrongfully and they have been brought to a wrongful restraint, anybody can go and apply for this habeas corpus writ. Now, in reference to this arbitrariness, to this administrative discretion, I am referring to the case of A.K. Gopalan versus State of Madras. As most of the law students would be very much acquainted with this case, that A.K. Gopalan was, as the fact known to us, and a quick recap of the fact is that A.K. Gopalan was the communist leader in Madras, and he was detained under Preventive Detention Act 1950, and for the longest period of time he was not brought to trial, neither brought in front of the magistrate within 24 hours. Now, this is a clear violation. Now we know that it is a clear violation of principle of natural justice, but back at that time, and around 1947, he was not put to trial, he was not given a chance to be heard, and then this writ was invoked under Article 32 clause 2 of the Indian Constitution, stating the habeas corpus writ. Now, he was not brought, he was not given a chance to be heard, and it was one of the first cases of violation to principles of natural justice. And in due course and in due reference to this case, the Supreme Court had brought out an erroneous judgment by not giving the due justice that A.K. Gopalan had demanded back at time, and this was overruled. A.K. Gopalan versus State of Madras was overruled by the Menka Gandhi versus Union of India. Now, here, before stating Menka Gandhi versus Union of India, there is no reference to habeas corpus, but why this case is very paramount to be discussed here is that this case brought out the arbitrariness that the administration had shown. Now, Menka Gandhi had applied for her passport in 1967, but she did not get her passport. And from the passport authorities, no such reasons were given for giving her the passport. Now, she for through a number of letters, through a number of queries, through a number of ways, she had asked the passport authorities why such a mode was taken for arbitrarily taking down her passport, arbitrarily not answering her, because she was in dire need for movement to a foreign country. Now this is where I want to draw this fact that what an administrative discretion can bring out to a person, the desperate need of getting your rights enforced through these, is what writs inhibit in itself. Now, one of the earliest cases of this principle of natural justice, as already stated in A.K. Gopalan versus State of Madras, it brought out the need of the the Indian judiciary to look through the lenses that what an individual requires or what an individual expects from the judiciary. We know that judiciary is that part of the it is a part of us, it is a part of all our individuals, because at the end of the day, any violation happens, we know that we have an enforcer of our rights, we have an enforcer of our rights who will take care of our rights and who will bring out the justice that we require. Now, the habeas corpus case, as it should be discussed with reference to this habeas corpus writ, is ADM Jabalpur versus Shivakant Shukla. Now, this was the earliest cases during the emergency time, where Mrs. Indira Gandhi, to a lot of extent, to exert her power, her pressure over all the people to set aside these political parties and get through the and bring out the Congress supremacy. There, she kind of let every parties to not come through her way or not come in her way of exercising her power to her fullest. Now, ADM Jabalpur versus Shivakant Shukla is known as the habeas corpus case, and this was the case where again it was an erroneous judgment, as said, and as the legal history states, that at a time when all these people who were brought behind the bars, who had all the opportunities to be brought to the court, to be heard, were taken away. Neither they were heard, neither their trials, the fair hearing that we say by way of principal justice, were heard. Now, habeas corpus in a lot of ways has brought out the cruelty that happens within the society. A lot of times it has happened that under dowry death cases, many dowry death cases have happened where the woman has not been brought out, the woman has not been able to place her demands because she was under a humongous pressure of not voicing her views. So that is how why this habeas corpus is of much importance, is because it also somehow brings out the power of an individual, or in that case any person who knows that this is not right can go and apply for this writ to be invoked for that individual. So previously I have discussed about all those highlights of cases which are attached to habeas corpus and which are paramount to be understood. So with this understanding, we also need to understand how this habeas corpus has come into the picture of Indian Constitution, and how have we come through various ways of understanding why this habeas corpus is really important to be induced into each one of us, so that we have a confidence that nobody can show the arbitrariness and do any sort of actions which go beyond the principles of natural justice. So Coming back to the origin of habeas corpus, one of the origin of habeas corpus is to be traced since 1215, when King John had signed the Magna Carta, and within this Magna Carta there was a clause, which is the 39th clause of the Magna Carta, which states that no man shall be arrested or imprisoned except by the lawful judgment of his peers and by the law of the land. Again, it was because we have a lot of takings and learnings from the US judiciary, we have incorporated it by also way of the concept of habeas corpus, which is embedded in the United States by through the first Judiciary Act of 1789, where the Congress explicitly authorized the federal courts to grant habeas corpus relief to federal prisoners. Now, if we have if we also see the England system, which is one of the main reasons why we have a uniform legal system, or the backbone of the legal system, or we can say the imprints or the blueprint of the legal system that we see today have come from the learnings from England and the rule that British did in India. Apart from many other things, it brought one of the pillars of legal system to India. So in England there used to be this act of habeas corpus act, where it said that no man should be detained unlawfully, illegally and unreasonably, without following the principles of natural justice, without giving them the opportunity to be heard. So that is how we have incorporated the habeas corpus writ into our system, ensuring that each and every person's liberty, each and every person's right to life guaranteed under Article 21 of the Indian Constitution is ensured by way of these writs, with special reference here today with the habeas corpus writ. Now, it is very important to be discussing about ADM Jabalpur versus Shivakant Shukla, whereby the court held after in that case it held for an erroneous judgment, but after the 44th amendment of the Indian Constitution, it was held that Article 20 and Article 21 of the Indian Constitution cannot be hampered, cannot be suspended in any conditions, not even during emergency. Now, why Article 21 is because the personal right of liberty, the personal right to life, the right to ensure that all the essentialities of life is fulfilled through this Article 21. And this Article 21 is so important that Article 32, without Article 21, Article 32 would be the procedural aspect would be shadowed, because Article 21 cannot be enforced. So by way of Article 20 and Article 21, Article 32 is given an additional power to ensure that each individual right is, it is it is of absolute and the most priority to the judiciary, that the fairness is ensured and it is taken forward, and which was given again in ADM Jabalpur versus Shivakant Shukla, that was not ensured during obviously the emergency times were difficult, and back then we did not have so much of development, so it was not ensured. But by way of many amendments through this day, we have seen that judiciary has been able to upheld a lot of unlawful detention of those who require the reasonableness and the right to know why they have been detained. So again, in one of the famous cases of Sunil Batra versus Delhi administration in the year 1979. On 28th December, it was said that even the facts of the case went by that even though the prisoners, the convicted prisoners are in the prison serving their life term, which was back then the one of the peers of this prisoner was going through a brutal cruelty of the prison authority. Here the Supreme Court was very kind enough to take this petition under the habeas corpus writ to ensure that even though the person is serving the life imprisonment sentence given by the honorable high courts, it is imperative to ensure that their life in the prison is not full of cruelty. The prison authorities cannot have the cruelties, cannot have the discretion going on beyond what they should do. So Sunil Batra versus Delhi administration is again one of the landmark judgments which has brought out that even you have been detained, even the prisoner has been detained, even they have been serving the sentence, they are not required to face such brutalities from the prison authorities. Again, in these cases, we have come out with this view. A lot of people from many aspects have come out this view that because of habeas corpus we are able to thrive. The very existence of the individual, the main motto, the soul is being protected by way of habeas corpus. Through this we are able to bring out the brutalities that delegation of work to these administration. It would be right to say that the delegation of work that has been given by way of parliamentary rights to these administrative bodies, if they go beyond what they should do, they will be facing the consequences, because the writ jurisdiction which is there in the Indian Constitution, we should not forget that every human life counts, and in India we respect the fact that each and every human being is very dear to everybody, and we are very we want the justice to thrive. We want the justice to keep on, the torch of justice should never be faded. And this is how the habeas corpus writ with reference to writ in general is discussed in this video. I hope this adds to your knowledge dictionary, and if in case you have some comments, it will add to my knowledge dictionary. Thank you.